Hello, everyone, and welcome to Internet Law Review. For today's story, we have the case of Garza versus Idaho. This is a case dealing with a criminal defendant who, as part of a plea bargain, signed a waiver that said that he waived his rights to appeal. However, he wanted to appeal anyway. His lawyer decided not to file the notice of appeal on the basis of the waiver. The issue the court is trying to reach is whether or not that was a misconduct on the part of the lawyer. So let's see what the court has to say and discuss a little bit about their opinion. Petitioner Gilberto Garza signed two plea agreements, each arising from state criminal charges and each containing a clause stating that Garza waived his right to appeal. Shortly after sentencing, Garza told his trial counsel that he wished to appeal. Instead of filing a notice of appeal, counsel informed Garza that an appeal would be problematic given Garza's appeal waiver. At the time period for Garza to preserve an appeal lapsed, he sought state post conviction relief, alleging that his trial counsel had rendered ineffective assistance of counsel by failing to file a notice of appeal despite his repeated requests. The Idaho trial court denied relief, and the Idaho Court of Appeals affirmed. Also affirming, the Idaho Supreme Court held Garza could not show the requisite deficient performance by counsel and resulting prejudice. In doing so, the court concluded that the presumption of prejudice recognized in Roe v. Flores-Ortiga, when trial counsel fails to file an appeal as instructed, does not apply when the defendant has agreed to an appeal waiver. So generally in a criminal case, there are certain rights that a criminal defendant has and certain decisions that only a criminal defendant can make. And the counsel cannot make certain decisions for him. These rights include the right to decide whether or not to plead guilty, the right whether or not to testify as part of your own defense, and the right to decide whether or not to go to appeal. Each of these are decisions that the defendant and defendant alone can get to make. The counsel, of course, can advise them, but ultimately it's the defendant's decision to make, regardless of how ill advised the lawyer might think it is. So in this particular situation, the defendant signed an appeal waiver and wanted to appeal anyway. So the question is, does the defendant's normal right to decide whether or not to appeal still apply, even though there's a waiver of the right to appeal? So let's see what the court decided. Held. Flores-Ortiga's presumption of prejudice applies regardless of whether a defendant has signed an appeal waiver. Under Strickland v. Washington, a defendant who claims ineffective assistance of counsel must prove that counsel's representation fell below an objective standard of reasonableness and that any such deficiency was prejudicial to the defense. However, prejudice is presumed in certain Sixth Amendment contexts, such as when counsel's constitutionally deficient performance deprives a defendant of an appeal that he otherwise would have taken. This case hinges on two procedural devices: appeal waivers and notices of appeal. No appeal waiver serves as an absolute bar at all appellate claims. Because a plea agreement is essentially a contract, it does not bar claims outside its scope. And like any contract, the language of appeal waivers can vary wildly, leaving many types of claims unwaived. A waived appellate claim may also be preceded if the prosecution forfeits or waives the waiver, or if the government breaches the agreement. Separately, some claims are treated as unwaivable. Most fundamentally, the courts agree that the defendant retains the right to challenge whether the waiver itself was knowing and voluntary. So, a couple things of note here. When you are pleading to a crime as part of the plea bargain to get a reduced sentence or reduced charge or other sort of benefit, the government typically requires, among other things, that you agree to waive your right to appeal. The idea being that if you want to appeal the conviction, you should go to trial in the first place. That's where the right to determine whether you're guilty or not lies. So if you want to plead guilty, you certainly can, but it doesn't make much sense to then turn it right around and say, well, my conviction was improper. If you wanted your conviction to be decided by a court, you just waive that for the benefit you receive. So fair enough. However, many of these waivers are not absolute. They often contain an exception allowing a criminal defendant to challenge the constitutionality of the conviction or challenge the law of the conviction. So, not a fight over the facts, but a fighting over the meaning of the law or the application of law, because that would be a decision for a court of appeals. So, you're essentially confessing to the facts, but saying the law doesn't apply or shouldn't apply because of some reason. That would be a typical exception to this rule. And it can contain other exceptions as well. For example, the plea agreement usually requires the prosecution to recommend either a specific sentence or recommend a particular range of sentence. So if they go outside that range, they could appeal. And sometimes you'll see agreements that say, we're recommending a range, but the judge can go higher than that range because sentencing is at the discretion of the judge. But if the judge goes above a certain range, you have a right to appeal. So there's a whole bunch of conditions that can be put in these things. And as noted, there's certain things you can't waive regardless. There would be the issue of subject matter jurisdiction, whether the court had the right to hear the case at all, because whether it's a proper subject for the court, that can be brought up at any time on an appeal at any level for the first instance. So that'd be an example. And as here, they're saying whether or not the waiver itself was constitutional. You can make an argument that it was coerced or otherwise not knowing or voluntary. So that's something you could fight, even though the language says no appeals. So fair enough. The Supreme Court continues. The filing of a notice of appeal is a purely ministerial task that imposes no great burden on counsel. Filing requirements reflect the appellate claims are likely to be ill-defined or unknown at the filing stage. And when the division of labor between defendants and their attorneys, the ultimate authority to decide whether to take an appeal belongs to the accused. Garza's attorney rendered deficient performance by not filing a notice of appeal in light of Garza's clear requests. Given the possibility that the defendant will end up raising claims beyond an appeal waiver's scope, simply filing a notice of appeal does not necessarily breach a pre-agreement. Thus, counsel's choice to override Garza's instructions was not a strategic one. In any event, the bare decision of whether to appeal is ultimately the defendant's to make. Because there is no dispute that Garza wished to appeal, a direct application of Flores-Ortiga's language resolves the case. Flores-Ortiga reasoned that because a presumption of prejudice applies whenever the accused is denied counsel at a critical stage, it makes greater sense to presume prejudice when counsel's deficiency forfeits an appellate proceeding altogether. Because Garza retained a right to appeal at least some issues despite his waivers, he had a right to a proceeding and was denied that proceeding altogether as a result of counsel's deficient performance. That he surrendered many claims by signing appeal waivers does not change things. First, the presumption of prejudice does not bend because a particular defendant seems to have poor prospects. Secondly, while the defendant in Flores-Ortiga did not sign an appeal waiver, he did plead guilty, which reduces the scope of potentially appealable issues on its own. Contrary to the argument by Idaho and the U.S. government as amicus, Garza never had the right to appeal, and thus any deficient performance by counsel could not have caused the loss of any such appeal. Garza did retain a right to appeal. He simply had fewer possible claims than some other appellants. The government also proposes a rule that would require a defendant to show, on a case-by-case basis, that he would have presented claims that would have been considered by the appeal court on the merits. This court, however, has already rejected attempts to condition the restoration of defendants' appellate rights forfeited by ineffective counsel on proof that the defendant's appeal had merit. Moreover, it's not the defendant's role to decide what arguments to press, making it especially improper to impose that role on defendant simply because his opportunity to appeal was relinquished by deficient counsel. And because there's no right to counsel in post-conviction proceedings, and thus most applicants proceed pro se, the government's proposal would be unfair, ill-advised, and unworkable. Sotomayor filed the opinion of the court, and Justices Thomas, Gorsuch, and Alito filed a dissenting opinion, so this is a 6-3 opinion of the United States Supreme Court. I'm somewhat conflicted on this opinion by the U.S. Supreme Court because of some of the rules governing attorney ethics. One of the rules for attorneys' ethics is that attorneys cannot present arguments they know to be frivolous. So if you're presenting an argument for the court, you have to present one that is in line with the current law. And if you want to change the current law, you have to have a good reason for doing so. And the more cases that support a particular proposition, the better your argument needs to be, because you're looking to fly in the face of something that's been long established. It's not to say that you can't argue it. You can. You just have to have really good reasons, and you can't present an argument that has no basis in logic or no basis in reason whatsoever. That's a frivolous argument. If I was this guy's attorney, and he had filed a waiver that said he gave up all his rights to appeal, I certainly could file a notice of appeal. But when it comes to the actual appeal, what am I supposed to do? I can only see two arguments that I can make. The first argument I can make is that the waiver of the right to appeal was not made knowingly, voluntarily, or intelligently. Part of the problem there is that these agreements often require counsel themselves to sign off on the fact that they gave the advice of counsel to this person to make sure that they understood what they're doing. So, in some ways, I would be suggesting that I was either giving bad advice or perhaps misrepresenting things to the court. So, I'm putting myself in a slightly precarious position because my own signature here might help to defeat some of the arguments I've been trying to make. The only other argument I could make is for ineffective assistance of counsel generally. Basically, I could be arguing that the attorney, which in this case would be me, was so hopelessly inefficient at the trial stage that he prejudiced the client and this agreement should never have been made because it's such a horrible deal. So basically, I'm in a position where I'd have to be argued that I was incompetent at the time, and knowing that, the Court of Appeal should overturn it because of my own incompetence. You can obviously see the conflict of interest that arises there. So my main objection to this case is not in the filing of the notice of appeal. I would tend to agree with the Supreme Court that's a ministerial act. My objection is, what am I supposed to do afterwards? As the Supreme Court notes, the arguments on appeal are an issue for the attorney. And this applies all the time because just because you have 10 possible arguments doesn't mean you should make all 10. There's strategic considerations, tactical considerations on what issues you should or should not raise, and those can be really complicated. But if I have nothing to work with, then I file this notice of appeal, and then what? I'm supposed to just abandon it when my deadline comes? Or file a paper saying I have no arguments? I mean, how prejudicial is that? So the Supreme Court doesn't really say what I'm supposed to do if I, in my best judgment, don't believe I have any viable arguments. I can file the notice of appeal, but then what? I suppose I could drop myself as attorney and tell him good luck on your pro se, good luck on filing whatever you want to yourself. I would hope that my retention agreement is written in such a way to give me my option, because I don't want to be put in a position of filing a notice of appeal only to then say, oops, never mind, I'm not going to file the paperwork. It's a bit disrespectful to the court, and I prefer not to be in this option. So I think on balance, the dissent in this argument might have the better end of the argument. I'm not sure I can agree with the majority's conclusions. But for now, my friends, that is all. I hope you're well. Until later, cheers and goodbye.